Welcome back to Shaikhain, and I am Saeed Shaikh. A consultation clause, being an essential provision in a contract, typically outlines that the parties have promised to give something of value or render service in exchange for something of value or service to them. The most common form of consultation is the exchange of goods or services for a fee, money, or some form of monetary compensation. An example of this mandatory provision could be found in a real estate transaction where a party will legally agree to deliver title to a property in exchange for the purchase price. Likewise, in an employment contract, an employee will agree to render services in consideration for salary as well as the perks, etc. A contract is said to be invalid if it does not contain a recognizable consideration clause. However, some of the exceptions thereof would include when the agreement is more of a promise of a gift and not a contract. In the Contract Act 1872, there are three kinds of consideration. These are past consideration, present consideration, and the future consideration. On the basic principles of contract laws, the consideration is the answer to the question, why are you entering this contract? Or what you are receiving for being a party to this contract? So, ladies and gentlemen, when you are entering into a contract, please do consult your contracts expert lawyer to make sure that no such mandatory provision as required under the law is missing in order to make the contract valid and enforceable. So, this was a brief on the consideration clause. If you need to discuss the terms of your contract as well as your contractual issues with our contract expert lawyer, you may contact us through email or our WhatsApp number. And don't forget to subscribe our channel for watching more videos on professional topics. Thank you.